1 2 1 2.
2. Testing 1, 2. The House Chairperson.
There will now be an opportunity for silent prayer or meditation. Please be seated. The Secretary will read the order.
Debate on vote number 27, Office of the Chief Justice Appropriation Bill.
The Honourable the Minister of Justice and Constitutional Development.
Malibongwe, Malibongwe.
Thank you very much, House Chairperson. Let me first acknowledge the Deputy Minister of Justice and Constitutional Development, Andrew Snell, Chairperson of the Portfolio Committee Honorable Xola Ngola, and members of the Portfolio Committee, ministers, deputy ministers, members of parliament, distinguished members of the judiciary, heads of professional law bodies, the acting secretary general of the OCJ, Ms. Potgieter, and the collective leadership of the OCJ, the director general of the Department of Justice and Constitutional Development, distinguished guests, honorable members. It has been 30 years since President Mandela first opened the doors of the Constitutional Court on 14 February 2025 on the occasion of its inauguration. On that day, President Mandela said, I quote, "The last time I appeared in court was to hear whether or not I was going to be sentenced to death. Fortunately, myself and my colleagues were not. Today, I rise not as an accused person, but on behalf of the people of South Africa to inaugurate a court South Africa has never had, a court on which hinges the future of our democracy. It is not just a building that we inaugurate, handsome though it is. It is not a body of wise men and women that we launch on their path, important though we regard their work. It is not our blessings that we give to their work, confident as we are in their integrity and commitment to justice. It is an institution that we establish, South Africa's first constitutional court," unquote. President Mandela concluded by saying, "The success of the Constitutional Court will depend in large measure on the successful functioning of the ordinary courts. Every court, from the most isolated magistrate court to the appeal court in Bloemfontein, has a role to play. The letter and the spirit of the Constitution must permeate every aspect of justice in our country." Honorable members, I recount these words to remind us of the responsibility given to us by our forebears to safeguard not only the highest court in our land, but the judiciary in its entirety. Section 165, subsection 4 of the Constitution compels all organs of the state through legislative and other measures to assist and protect the courts to ensure their independence, impartiality, dignity, accessibility, and effectiveness. I am therefore honored to stand before this august House to present the OCJ's program and budget for 2025-2026 financial year. Through this budget, we are once again demonstrating our commitment to not only supporting the Office of the Chief Justice, but the entire administration of the justice in our country. The OCJ provides direct support to the judiciary and superior courts to ensure that the judicial arm of the state functions optimally. As such, the OCJ has been allocated a budget of 2.7 billion for the 2025-26 financial year, which it operationalizes through 3 programs, namely administration, superior court services, as well as judicial education and support. This allocation also includes the direct allocation for the remuneration of judges. This represents, honorable members, an increase of just over 5.5% compared to the previous financial year, which will go a long way in ensuring efficiency, effectiveness of the courts and the judiciary as a whole. In his budget speech earlier this year, the Minister of Finance has also made an undertaking to later this year make funds available for strengthening capabilities in the Office of the Chief Justice. Despite the budget increase, honorable members, there are still shortfalls for infrastructure-related support, security in courts, capacitation of the judiciary. So we are therefore looking forward to the adjustment as announced by the minister so that we can be able to give the full support as committed to the judiciary. Currently, the allocated budget, honorable members, vote for the voted fund is 1.5 billion, of which 1 billion is for compensation of employees, and just above 407 million is for goods and services, 1 million is for transfers and subsidies, and 89.7 million is for purchase of capital assets. The budget for direct allocation is 1.2 billion, of which 1.1 billion is for compensation of judges and 101 million is for transfers and subsidies. The APP gives practical expression of the OCJ's mandates of supporting the judicial branch of the state while demonstrating how the department will contribute to the priorities outlined in the NDP and in the MTDP. In line with this, the following will remain the strategic focus areas of the OCJ. Facilitation of training to judicial officers, modernization and digitization of court systems, strengthening capacity for ensuring business continuity and management, ensure that ICT remains a strategic tool for business efficiency, curbing opportunities for fraud and corruption, promoting professional ethics within the organization, improving the capacity of the department with more focus on the core functions, and ensuring occupational health and safety. Honorable members, on the modernization and digitization of court system, we can account of court system remaining key priority for the OCJ to improve access to justice in terms of that program. The OCJ has continued apace with the rollout of the court online system to various superior courts, following a successful piloting of the system in the Gauteng division of the High Court. Court Online provides a platform for law firms, litigants to file documents to the court electronically over the internet from anywhere they are. And it is now in operation in Gauteng, fully, Western Cape, KwaZulu-Natal, Mpumalanga, Limpopo, and currently underway in Eastern Cape, which we are expecting to be concluded by end of July 2025. It is also being progressively implemented at the Land Court and Labour Court and Labour Appeal Court. The envisaged full implementation of all this process will enhance access to quality justice for all and the effectiveness of running our courts. On strengthening capacity, honorable members, as of the end of 2024-25 financial year, the overall implementation of the OCJ's Business Continuity Management System project was at 95%, with Business Continuity Plan compilation being at 90%. The Business Continuity Management System is designed to ensure that the department is continuously customer-orientated and promotes excellence in the delivery of service. This excellence delivery of service is meant to be a reality even in the event of possible disruption, including disaster situation. Again, honorable members, in line with the organization's zero tolerance to fraud and corruption approach, the OCJ will implement the department's fraud prevention and anti-corruption policy and strategy for the financial year 25-26. This policy creates a mechanism, amongst others, for the department to receive anonymous reports through the anonymous reports within the department and the National Anti-Corruption Hotline. We can inform honorable members that following the reports of corruption in the Mthatha High Court, the OCJ has commenced with lifestyle audit for all employees at that court, and this is over and above the work that is being done by law enforcement agencies in that area. Furthermore, in terms of the Gauteng, the Pretoria High Court, following allegations of fraud and corruption, 4 officials have been suspended and investigations are underway. The OCJ aims to finalize quasi-judicial matters within prescribed timeframes and monitor the enhancement of the court order integrity and implementation of the judicial case flow. And we'll see this as we look at the report that is being presented by the OCJ and also all the courts in terms of their performance. In this financial year, honorable members, we will commence with the process of placing the judiciary on the path to a full institutional independence, which will enable the judiciary to be a fully fledged arm of the state. In line with the Constitution and as announced by the President, the judicial governance and court administration will be placed under the authority of the judiciary itself. Accordingly, this model will entail structural independence, which includes financial independence and operational independence. With a vision to establish a single judiciary, the administration of the lower courts, including the Magistrate Commission, will also be transferred to the Office of the Chief Justice. In terms of the proposed model, the Chief Justice will become the executive authority of the Office of the Chief Justice. The Secretary General will be accounting authority of the judiciary. The OCJ will then be re-established outside the public service and be capacitated to appoint its staff in line with its own prescripts, human resource framework tailored to judicial operation and principles of independence. To carry out this process, a task team has been comprising of senior officials of the Department of Justice and Constitutional Development, Presidency, Office of the Chief Justice, National Treasury, DPSA, and the Department of Public Works and Infrastructure has been established to chart a way forward for the institutional independence of the judiciary. The task team was given until the end of August to provide a progress report to be presented to Cabinet on the institutional independence of the judiciary. In the end, as envisaged by the founders of our democracy, we want to create a single judiciary that is equal to all arms of the state. Honorable members, it is opportune that as we celebrate 15 years of the OCJ, that we reflect on the achievements of the organization in support of the judiciary. The following are some of the successes of the OCJ since its establishment. The department moved from 74% achievement of its targets to 86% from 2015-2016 financial year to 2023-24 financial year. Improvement in the audit outcome moved from unqualified audit outcome in 2016-17 to clean audit in 2 consecutive years until 2018-2019, then regression but recovered back to clean audit for 2023-24 financial year. 2% representation of people with disabilities by the end of 23-24 financial year. 53% of women representation in senior management by the end of financial year, as we said, 23-24, the operationalization of the Limpopo Division of High Court, Mpumalanga Division of High Court, and the recently established Land Court as part of improving access to justice for all, enhancing access to justice to the people of South Africa through the rollout of the court online system to 16 superior courts. As President Mandela stated in February of 1995, the judiciary is the guardian of our nation's fundamental rights and justice that must not be broken. It is the task of the judiciary to ensure that the value of freedom and equality which underline our constitution are nurtured and protected so that they may endure. I would like to extend a word of appreciation to the Chief Justice of South Africa, Chief Justice Mandisa Maya, for her judicious leadership of the judiciary, and all the heads of superior courts in our land for their tireless work towards efficient administration of justice. I also wish to recognize the Acting Deputy Chief Justice of South Africa, Justice M. Madlanga, who takes retirement later this year. We thank Justice Madlanga for his service and wish him a happy and restful retirement. The constructive oversight role played by the Audit and Risk Committee of the OCJ should also be acknowledged. Last but not least, I thank the Acting Secretary General of the OCJ, the management team of the OCJ and staff for their dedicated efforts in serving the people of South Africa. And lastly, thank the Deputy Minister, the Portfolio Committee for the guidance and support as always. I hereby, Chairperson, table the budget vote for the Office of the Chief Justice for approval by the House. Thank you.
Thank you, Honourable Minister. I now recognize the Honourable Ngola.
Thank you very much, House Chair, the Minister and the Deputy Minister, members of the House, the Acting Secretary General of the Office of the Chief Justice, and the Director General of the Department of Justice. House Chair, this year marks 70 years since the adoption of the Freedom Charter. The Freedom Charter called for equality before the law. It called for cause that would be representative of all people and that no one would be imprisoned without a fair trial. The ideals of the Freedom Charter would later be imported and entrenched in our final constitution. The Freedom Charter envisaged a system of government where the judiciary would be independent, both institutionally and operationally. It is for this reason that the Office of the Chief Justice was declared a separate department with its own budget. The independence of the judiciary is the bedrock of the democratic system of government. It is universally accepted that the independence of the judiciary is a sine qua non of a democratic state. The Office of the Chief Justice is allocated 2.7 billion in 2025-2026, including a direct charge for judges' salaries, which grows to 3 billion over the medium term. 1.5 billion is allocated to the vote and 1.2 billion is a direct charge for judges' salaries. In real terms, however, the allocation grows by slightly less than 1% when compared to 2024-2025 financial year. The OCJ reports shortfalls, including for infrastructure-related support, security in courts, and the new priorities such as the Land Court, Durban High Court, and implementation of the Moseneke report. However, these shortfalls form part of discussions among various stakeholders, and in this regard, the committee knows the minister's assurance that additional funding will be allocated over the medium term. The Land Court Act was passed to establish a special land court. The court is to facilitate the expeditious resolution of land cases and contribute towards the development of appropriate jurisprudence in relation to land matters. When enacting this legislation, we are acutely aware of the challenges and frustrations facing litigants in land matters. We sought to ensure land justice. The committee knows the shortfall reported for the implementation of the Land Court Act 6 of 2023. We have requested a comprehensive report on the operationalization of the Land Court and Land Appeal Court. The report should reflect on the funding, resources, and capacity needed to operationalize the Land Court and Land Appeals Court. The committee knows that additional funds will be allocated to the OCJ to fill critical positions, including the appointment of researchers to support judicial functions. The judicial raised the lack of research support during the committee's recent visit to Durban High Court. As such, these appointments are most welcome. A single judiciary is a constitutional injunction. The term single judiciary commonly refers to a process where magistrates and magistrate courts are integrated to form part of a unified court system. The committee has expressed concern about the failure to resolve the matter of the judiciary's institutional independence. Presently, the responsibilities and funding for court administration are fragmented. This results in the judiciary having to rely heavily on the executive for its operations. Considering the journey traversed in ensuring a single and independent judiciary, we must acknowledge the report that there has been engagement between the president, supported by the minister, deputy minister, the chief justice, and heads of court. Several other ministers were present, including the ministers of finance, public services and administration, and public works. The committee knows that the OCJ recently advised that its court online system is now operational in the Western Cape and KwaZulu-Natal divisions of the High Court. Following a successful pilot in Gauteng High Court, the system is also being progressively implemented at the Land Court and Labor Appeals Court. The Limpopo High Court was to go live in April 2025, and implementation at the Mthatha High Court has been expedited at the request of the Chief Justice to address allegations of impropriety at that court. The committee welcomes the progress, but considering the delays in rolling out the solution, it will continue to monitor the implementation closely. The committee requests a comprehensive report with details of the OCJ's plan to roll out the solution to all courts by 31 July 2025. The South African Judicial Education Institute was established to develop the skills of current and prospective judicial officers. It has been reported that the OCJ plans to offer 80 judicial education and training courses each year over the medium term through SAJE. We commend the SAJE on the launch of its academic journal, South African Judicial Education Journal. The committee knows with concern the recent allegations of corruption by OCJ officials at Mthatha High Court. The Chief Justice conducted an oversight visit to the court, meeting with the acting judge president of the division, as well as senior OCJ officials. It has been reported that a case was opened with the South African Police Service and the Directorate for Priority Crimes Investigation launched an investigation. This process is running concurrently with OCJ's own internal investigation. It has been reported that the OCJ has begun lifestyle audits of officials at that court. This is also welcome. The committee is disappointed to learn that the completion of the Durban High Court has been delayed to June 2026 because of the lack of funding. The court is currently housed in the Durban Magistrate Court, which has its own structural challenges. This contributes to backlogs and a clogging of the system. The committee intends to engage with the various ministers and stakeholder departments about its findings in due course. In the meantime, the committee requests OCJ and Department of Justice to provide a comprehensive report on the matter. The committee, having considered vote 27, Office of the Chief Justice for 2025-2026 financial year, and the strategic plan for 2025-2030, and annual performance plan for 2025-2026 of the Office of the Chief Justice, recommends that the House approves the budget. Thank you very much.
Thank you, Honorable Nombolo.
Thank you very much, House Chair. House Chair, I think I would have committed a monumental blunder if I do not start by saying that the APP, both the APP and the report which has just been tendered here by the chairperson of the Portfolio Committee, they are just suggestive of piecemeal palliative reforms to which the OCJ has been subjected to since its proclamation in 2010 by the president, who was the president at that time. We're not just making a halapalu when we're making that proposition. We're making a scientific perspective for whose reasons and we're going to, to which we're going to allude as we continue to make our presentation herein. Honorable members, we want to start by reminding you that when the office of the Chief Justice was proclaimed on the 23rd of August 2010, it was in line with cementing the doctrine of separation of powers, which in simple terms means that specific functions, duties, and responsibilities are allocated to distinctive institutions with defined areas of competency and jurisdiction. Separation of powers is, in short, separation of public institutions, namely the legislature, the executive, and the judiciary. This instrumental function of separation of powers was established for numerous reasons, but not limited to strengthening our democracy, to prevent tyranny, to safeguard individual rights, to enhance accountability, to promote stability, and to ensure that power is shared and not concentrated in one branch. Honorable members, we thought it is of importance to reflect on the aforementioned to enable all of you to understand the basis of our great feeling of unease, which premises from the fact that this government of national unity is determined at downplaying the importance of the judicial authority in our country. They are determined at reducing the judiciary to being an entity of the executive. Even though as the MK party were clear on our observation that some judges or former judges like Mr. Zondo have put the name of the judiciary into disrepute by allowing to descend into a political arena. We affirm in our call on the independence of the judiciary, which is completely immune from undue political influence. Subsequent to that, we once again maintain
Honorable Nombolo.
position that the
Honorable Nombolo, please,
is not
just,
only be responsible.
Honorable Nombolo, just take your seat for a moment. I have a hand to my left. Honorable Swart, why do you want to be recognized?
Chairperson, I'd like to raise a point of order in terms of Rule 88, and that is upon reflecting upon judges, that no member may reflect upon the competence or integrity of a judge of a superior court. And I'd ask whether the reflection or the comments about the former Chief Justice Zondo are in breach of that rule. Thank you.
Yeah, Honorable Swart, for me to consider the matter, you must please address me on the balance of the rule. The balance of the rule say whose removal from such office is dependent upon a decision of the House. So I need your argument as to whether that would still then apply to a retired judge.
Yes, Chair, I'm pleased that you raised that issue because we have had the examples of retired judges where we have impeached retired judges as well. And so I would argue that this rule applies to retired judges as well.
Yeah, thank you. Look, I'll recognize one or two members who's raised hands. We have a debate to deal with, but for me to properly deal with the point of order, I'll allow the Deputy Minister and the Honourable Douglas.
Chairperson, thank you very much. No, I think we need to recall that judges are appointed as judges for life. They do reach a stage where they are discharged from active duty, but they do remain judges and they can be recalled. So whilst former Chief Justice Zondo might have been discharged from active duty, he remains nonetheless a judge. Thank you.
Honourable Douglas.
Thank you, Honourable Chair. There's no absolute prohibition on mentioning a retired judge, and there's no law on it written in our rules. So I would suggest that this goes back to the speakers forum or to the programming committee. It gets discussed and it comes back to us, Mr. Chair. I think because for me this is a person that's retired from the bench. Obviously, we can understand if he's currently sitting over a particular thing, and we are subject to what the Parliament is going to be speaking about, that I can understand. But if he's retired and he's busy with other consulting work, he should be able to be mentioned as a private citizen in South Africa, Mr. Chair. Thank you.
Yeah, thank you. I've heard all of the arguments. Honourable members and Honourable Nomvalo, it is indeed so that I think the context in which we must consider the rule is the fact that even retired judges have benefits for life, which after a specific process, which would also involve a decision by Parliament ultimately, they may lose. And in that sense, for you to reflect on the integrity for retired Judge Zondo would fall foul of the rule. So I would request you to withdraw that remark. And if you feel strongly about it, bring the substantive motion Rule 88 refers to. Please withdraw.
I'll bring a motion, Chair.
Yeah, no, I need you to please
Subsequent
state on
to
the
that,
record
once
that you
again
would,
maintain
Honourable
our strong
Nomvalo,
position that
Honourable Nomvalo,
OJ must not only
Honourable Nomvalo, I've asked you to withdraw and then bring the motion. Will you please withdraw? Yeah, I'm still dealing with this point of order, then I will entertain further hands. Honourable Nomvalo, please withdraw.
Chair, I'll bring a substantive.
No, I need you to state on the record that you withdraw.
On which rule, Chair? Refer me to a rule.
Honourable Nomvalo, if one has made an unparliamentary statement, it is then requested, it is then within the rules for you to be required to withdraw. Yeah. Honourable Nomvalo. Honourable Nomvalo. Honourable Nomvalo, I'm going to give you another opportunity to withdraw that remark. That is how our rules and our practice deal with unparliamentary remarks. Are you prepared to withdraw that remark? Honourable members, I will not recognize hands after I've made a ruling on the same subject. I'm now with the Honourable Nomvalo. Honourable Nomvalo, I'm going to give you another opportunity to withdraw.
I withdraw, Chair.
Thank you. Please just pause for a moment. I have a hand to my left. Honourable Douglas, my ruling is final. We cannot revisit it in this sitting. You know that you may, if you're aggrieved with the ruling, write to the Speaker and ask that the matter be placed for the Rules Committee, before the Rules Committee. Do you want to address another matter?
No, this is Rule 88 that I'm speaking to. The
No,
current rule.
but I've made my ruling on Rule 88, so may I plead with you to deal with it in terms of the rules?
We will object and we won't take this matter further. Thank you.
Thank you. Honourable Skosana, is that now on a new matter?
Ngiyakuthokoza mgcini sihlalo. Mgcini sihlalo into oyenzako akusiyo. Akuna nje njengoba uhleli lapho akunamthetho okhuluma ngento oyithoko. Now usifaka ekhoneni ukuthi fanele sivume into oyithoko because lento ekhuluma ayikho emthethweni. Ayikho lento oyithoko emthethweni. Uyakwazi lokho.
Honorable Skosana, no, you, as a matter of fact, are now trying to revisit my ruling. You're perfectly entitled to have your view as to whether the ruling was correct or not. I've already indicated the action step now available to you and other members who feel aggrieved is to write to the speaker, lodge a complaint, and ask that the matter, if you also disagree with the rule or the ruling, be placed before the Rules Committee. Honorable Nomvalo, please continue.
Subsequent to that, we once again maintain our strong proposition that the OCJ must not only be responsible for superior courts, but also for lower courts. Placing the lower courts under the supervision of the Department of Justice is not only an undesirable contravention of the doctrine of separation of powers, but a severe direct violation of Section 165, subsection 1 of the South African Constitution, which provides that the judicial authority of the Republic is vested in courts, and subsection 6, which directs that the Chief Justice is the head of the judiciary and exercises responsibility over the establishment and monitoring of the norms and standards for the exercise of the judicial functions of all courts. Placing the lower courts under the supervision of incompetent and clueless GNU ministers who get deployed not through merits, but because of their extraordinary ability
Honorable
to be telling
Nomvalo.
us who are excellent lobbyists.
Honorable
And
Nomvalo,
sometimes
my
the South
apologies.
Is a disdain
Honorable Nomvalo.
for disaster.
Honorable Nomvalo, my apologies. I have a hand to my right. Just take your seat for a moment, please. Honorable Minister, why do you want to be recognized?
Thank you, House Chairperson. I rise on a point of order. The honorable member has just called me incompetent. It's an insult. And I would request that it be withdrawn, because if we are to be put to test, both me and him will never stand he will never stand the test of time. And therefore he can never say I'm incompetent, both in terms of experience, in terms of qualifications, in terms of ethical standard. You can't.
Yeah.
Therefore he must withdraw.
Thank you, Honorable Minister. What I heard the honorable member say is that we are faced with incompetent and clueless GNU ministers. So my understanding of his speech was that not necessarily directed at one individual, and therefore I'm not in a position to rule that he made himself guilty of. Honorable Minister, the rules similarly applies to members of the executive. So if you are unhappy with my ruling, you're welcome to also write to the speaker and request that the matter be placed before the Rules Committee. Thank you. Honorable Nomvalo, please proceed.
Thank you very much, Chair. We're not going to respond to people who project themselves as the mouthpiece of the GNU. The administration of justice requires superior technical skills whose brainchild will victoriously... Chair, I'm being disturbed. Can I be protected, please? Please, Chair.
Yeah.
Can I be
Honorable
protected?
members, let's allow the Honorable Nomvalo. He's now
Can I be protected?
been interrupted twice.
This overexcitement comes from. Can I be protected, Chair? Please.
Yeah, please proceed.
We wish to place it on record that we have studied with interest the APP for 2025-2026 and 5-year strategic plan presented by the Office of the Chief Justice to the Portfolio Committee. Upon dissecting it, we arrived to a scientific conclusion that it inter alia fails to address the following shortcomings which are presently affecting a proper administration of justice. The first shortcoming that it fails to address is a shortcoming of a case backlog. The OCJ proposes mediation as the only panacea to case backlog. We do not understand why they project mediation as the only amicable solution, whereas many cases are adjourned in court even when they are ready for trial. In civil court, RAF and police matters get adjourned even when the plaintiff attorney has met all the compulsory requirements. Instead of issuing judgments against the defendant, judges choose to adjourn them. The second shortcoming that they do not address properly is a shortcoming of lack of access to justice. The APP and strategic plan also do not address a vision to decentralize the high courts into district jurisdictions, in particular the local divisions. People travel 1,000 miles to access the High Court even after 30 years of democracy. It only talks about the online court system, which in our view will not be user-friendly to underprivileged communities whose residents have no access or do not have means to buy data. And then the third shortcoming that it doesn't address is a shortcoming of the lack of credibility of some judges. And we're going to say this unashamedly, that some judges are an embarrassment to the justice system of South Africa. Judges are not, and we must never treat judges as if they are people who are a paragon of virtue. They are human beings, they are corruptible. So they must be, hence as the MK party was saying, they must be subjected to a lifestyle audit, like all public servants, because they are human beings. Some judges get influenced on how they must adjudicate judicial matters. Some judges take bribes on how they, to influence how they should run their judicial responsibilities. We're making a call unashamedly so that there must be a lifestyle audit and all judges must be subjected to that process in South Africa. Thank you very much, Chairperson. We reject this report.
The next speaker is the Honorable Engelbrecht.
Honorable Chair, honorable members, in this debate on the budget allocation for the Office of the Chief Justice, we must acknowledge that this office is a cornerstone institution of our constitutional democracy. We are all aware that the judiciary is not merely a branch of government. It is the last line of defense for the rule of law, the guardian of our constitution, and the critical arbiter in the fight against corruption, maladministration, and abuse of power. On countless occasions in the past, it has been the final buffer protecting us from abuse of power by a corrupt government. The Office of the Chief Justice was established to enhance the institutional independence of the judiciary, to support the Chief Justice in her dual roles as head of the Constitutional Court and head of the judiciary. This is no small task, and yet, year after year, we are confronted with a deeply troubling reality. The Office of the Chief Justice is under-resourced, underfunded, and increasingly overstretched. In this financial year, the OCJ has been allocated 2.7 billion rand, an amount that may appear not insubstantial at face value, but is in fact insufficient to meet the institution's growing demands. Our judiciary is being expected to carry out its constitutional mandate without the tools and resources necessary for it to do so effectively. I will examine more closely some of the more obvious shortcomings that persist as a result of constant and chronic budgetary constraints. Inadequate support for the judicial case management. The case backlog remains a significant barrier to access to justice. Citizens wait months, even years, for matters to be finalized. This undermines public confidence in the legal system, while the judiciary has made strides in implementing case management systems, including digital case tracking. These efforts are hampered by limited IT infrastructure, insufficient staffing, and outdated systems that seldom work. Without substantial more funding, the modernized court systems and technology, the dream of digitally enabled, efficient judiciary will remain just a dream. Crumbling court infrastructure. Many courts across the country operate in deteriorating buildings that are not fit for purpose. Leaking roofs, and in some cases no roofs, power outages, a lack of accessibility for persons with disabilities, substandard ablution facilities. All these conditions not only compromise the dignity of our judiciary, but also the safety and efficiency of judicial proceedings. The roof at the Potchefstroom Magistrate Court has not been repaired for 3 years. The OCJ remains dependent on the Department of Public Works and infrastructure for maintenance, along with a myriad of other institutions, which often lead to prolonged delays and neglect. Greater direct control over its own infrastructure budget would empower the OCJ to address these issues more responsibly. All judicial officers and their support staff, if they have support staff, work under immense pressure, managing heavy caseloads with woefully insufficient administrative and research assistance. Law researchers are in short supply, clerks are overburdened. There is an urgent need for additional posts, especially in rural and under-resourced areas, yet budget constraints make it nearly impossible for the OCJ to recruit and retain skilled professionals. Each day we see the effect of this neglect on the ability of the courts to meet the needs of South Africans. Limited judicial education and training. The South African Judicial Education Institute, which falls under the auspices of the OCJ, is mandated with the critical task of capacitating judicial officials with ongoing education and training. This is particularly vital given the evolving nature of our legal framework, including new legislation, constitutional jurisprudence, and the imperative to transform our judiciary to reflect the demographics and lived realities of all South Africans. Yet, the Educational Institute is itself completely underfunded. Training programs, especially in specialized fields such as cybercrime, commercial law, environmental justice, and gender-based violence, are insufficient. This undermines both the quality and responsiveness of our judiciary. A lack of institutional independence in budget allocation. It remains a paradox that the Office of the Chief Justice must come before this House, cap in hand, to require funding, while its very purpose is to operate independently from the executive and legislature. This undermines the spirit of the separation of powers enshrined in our Constitution. A long-term solution must be found, including a model for financial independence for the judiciary, possibly through a constitutionally protected judicial fiscal authority. Let us be clear, when we underfund the Office of the Chief Justice, we do not simply inconvenience a department. We undermine the integrity of the judiciary and we erode the rule of law. We risk running justice into a privilege for the few rather than a right for all. Therefore, I suggest the following for urgent consideration: a significant increase in OCG's baseline budget, a comprehensive review of the budget allocation model, enhanced funding for the South African Judicial Education Institute, priority allocation for court digitization, and freedom from the Department of Public Works. A democracy is as strong as its courts. If we are sincere about strengthening the rule of law, fighting corruption, and ensuring that every citizen, regardless of wealth or geography, has access to fair and timely justice, then we must invest in our judiciary accordingly. We all talk about making justice more accessible, combating corruption, and getting a handle on crime. Well, honorable members, until we literally put our money where our mouths are, it is all talk. We must make this budget debate a turning point in how we resource and respect the judiciary. We must match our constitutional rhetoric with budgetary reality. If this government is serious about starting to eradicate crime and corruption, it will make more money available to do so. Currently, this is not the case. I thank you.
Thank you. Honorable members, Honorable Trollip has requested to speak earlier in this debate due to him having to travel to another parliamentary commitment. After consultation, the EFF agreed that he may be recognized before them. We thank them for that. I now recognize the Honorable Trolle.
Thank you very much, House Chairperson. I'd like to thank the EFF for granting me the opportunity to speak before them and the other parties that allowed me to leapfrog them. Action SA supports the budget vote 27 for the office of the Chief Justice. We do so because we believe that a truly independent and capacitated judiciary is not only the cornerstone of our democracy, but also a prerequisite for a capable, ethical, and developmental state. We welcome the President's recent announcements aimed at strengthening the independence of the judiciary, but let's be honest, announcements don't fix courtrooms, prosecute criminals, or restore faith in the rule of law. Chapter 14 of our Constitution speaks to the justice system's responsibility to promote accountability and combat corruption. Yet in these very areas, we are failing dismally, this in the year of the 30th anniversary of the Constitutional Court. If we are to reverse this trend, we must start by fixing what is broken. Our courts are collapsing under the weight of underperformance, under-resourcing, and systemic infrastructural neglect. One of the most urgent problem areas in our public prosecution performance. Too often, qualified and well-paid private counsel make a mockery of public prosecutors, running rings around inexperienced, underpaid, and overwhelmed state prosecutors. It's no wonder that so many cases are frequently bungled due to poor prosecution. At the same time, the remuneration of High Court judges is no longer competitive. The office of the Chief Justice cannot attract the best legal minds for private practice. And without top-tier judges, we simply cannot deliver top-tier justice. The impact of these failures is not theoretical. It is felt most acutely by poor and marginalized South Africans who cannot afford legal representation or repeated delays. For them, justice delayed is justice denied, with consequences that ripple through families and communities and that destroy lives. We welcome the Court Online initiative and the focus on judicial education, but digital reforms mean little if they're only partially implemented, or if they duplicate existing initiatives such as case lines, or if they're only partly implemented, or if the infrastructure supporting them is crumbling. Court buildings across the country, particularly in Johannesburg and Durban, are in a deplorable state. Leaking roofs, broken lifts, no fire hydrants, and emergency exits are locked, and malfunctioning toilets have become the norm. These sick buildings are not only demoralizing to staff and the public, but they are actively delaying justice. As long as court operations remain split between the Department of Justice and the OCJ, institutional independence remains compromised. We cannot have a judiciary that is constitutionally independent, but operationally dependent on the goodwill of the Minister of Justice. Chairperson, we will support the 2.7 billion rand allocated. We must be clear, though, that the increase of barely over 1% shows a lack of seriousness in addressing the deep-rooted issues plaguing our justice system. Action SA supports this vote, but we place on record our demand for bold reforms that restore the dignity, efficiency, and independence of our courts, in order that they can actually fulfill their constitutional mandate. We wish to wish the Chief Justice Godspeed and the wisdom of Solomon in fulfilling her now expanded responsibilities. In conclusion, in this House, we know that human beings are fallible and corruptible, as we know that some judges are fallible and corruptible too. This is all the more important for us to select unimpeachable justices. Thank you.
Thank you. I now recognize the Honorable Mohlala.
Thoma ka go dumedisha modulasetulo, ke dumedishe Commander-in-Chief, e le go Mopresidente wa EFF, Julius Sello Malema, maloko wa Parliament, boetapele jwa EFF ka moka ground forces and activists, le setšhaba sa bophara sa Afrika Borwa. Re mo le mokgatlo wa EFF go thekga budget vote 27 ya ofisi ya Chief Justice. E fela re thega rena le dipelaelo ka gobane tekanyetso ye ye nnyane kudu ge o e swantšha le mošomo o mogolo wa dikgoro tša tsheko mo nageng. Re tekanyetso ye e swanetše go oketša ka pela gore dikgoro di sewe. Minister, ge re lebelela 2.7 billion, e ka bonagala o kare ke e ntšhi kudu. Ge re ntšha di-salary tša baahlodi le ditšhelete tša theko ya dilo, re bona gore tekanyetšo ya nnete e oketšegile ka tlase ga 1%. Tšhelete e lego mo ga se ya go lekana, ebile ya go lekana go maintaina selo ka gare ga judiciary. Le ge judiciary e na le mešomo ye mentši ye e dulago e oketšega. Le ge baahlodi e le karolo ya motheo wa democracy, le ge boahlodi e le karolo ya motheo wa democracy, bo sa fiwa tekanyetšo e sa lekanego. Office ya Chief Justice e swanetše go šoma ka tokologo e fela infrastructure, ICT le security di ka fase ga vote 25. Se se bontšha gore tokologo ye ba e holofeditšego mengwageng ye fetileng ya go feta ye 10 ga se ya phetwa, Minister. Taolo ya judiciary ya rogane magareng ga vote 27 25, gomme se se hlola go se šome gabotse go diega le judicial infiltration. Taba ya case line e bontšhitše bothata, tender ya dimilione e filwe ka tsela ya boradia. Go fihlela le hono, parliamente ga se ya fiwa pego ya ditlamorago tša tshenyagalelo ye. Se se bontšha gore ga go tlhokomele ya nnete, ga gona accountability, Minister. Court online e be letetše go nolofatša dikgoro tša tsheko. E fela e thomile ntle le go lokiša gabotse. Cyber security kotsing ka gobane ga go bašomi ba ICT ba lekanego. Dikgoro tše ntši di sa šomiša dipampiri gomme go fetola dilo ga digital go sepela ka go nanya. Go bonagala go sa hlalosege gabotse gore mathata a tla rarolola jwang. Bothata jo bogolo ke dipheto tše di letetšwego go tšwa, the reserved judgment. Go tloga July go fihla August 2024, go ile go boloka dipheto tše 1602, tše 223 di fetile nako ya dikgwedi tše 3 yeo e beilego ke molaotheo. Se se laetša go diega ga toka, Minister. Mohlala ke Eric Lolo wa Wellington Western Cape, o ile a lelekwa mošomong ka 2016, case ya gagwe ile High Court ka 2017, sephetho se ile sa tšewa ka February 2021, e fela sa tšwa ka July 2022. Jwale appeal ya gage e dutše e letetše go tloga ka November 2024, se ke mengwaga ya go leta toka ya motheo, ke tshenyo ya nako le seriti. Dikgoro tša Pretoria, Mahikeng le Johannesburg di na le bothata jo bogolo ka go diega ga dipheto. Gauteng High Court e šetše e thoma go fa batho trial dates go fihla ngwaga wa 2031. Labour Court e na le baahlodi ba 13 fela mo nageng ka moka. Re ipotšiša gore re ka bolela jwang ka toka ya setšhaba go sena batho ba lekanego go dira mešomo. Mo mengwageng ye mentši, Minister, Afrika Borwa e bile le baahlodi ba ka bago ba 250 fela. Le ge mošomo wa bona o eketšega ngwaga ka ngwaga. Baahlodi ba šoma ka thata, ba bangwe ba ngwala dipheto bošego le di-weekend, ga bana bašomi ba go lekanela go ba thuša. Go akaretša le di-researchers, mešomo e dula e oketšega, gomme ka lebaka leo batho ba emela di-judgment tša di-case for mengwaga. Land Court ye e amogetšego ka 2022 ga e šome, ga go meago, ga go bašomi, ke molao fela o le go pampiring ga o šome ka nnete, Minister. Se se bontšha gore batho ba emetše toka ya naga mengwaga e mentši. Mafelong a mangwe dikgoro di senyegile. Durban High Court is delayed until 2026. Marulela a dikgoro a wela, di-pipe di a dutla, ba re sebakwa ke mathata a ditšhelete. Re thega tekanyetšo ye e fela re nyaka gore e oketšwe. Infrastructure, ICT le security di swanetše go ba ka fase ga OCJ, it's go Department of Justice. Land Court e swanetše go thoma go šoma pele ngwaga wa ditšhelete o fela. Re nyaka pego e feletšego ya taba ya case line. Re nyaka pego quarterly ya di-reserved judgment. Palo ya baahlodi e swanetše go oketšwa, gomme di-post tše vacant di tlatšwe ka pela, Minister. Re nyaka le research team go thuša baahlodi mošomong. Toka ya setšhaba ke molao, gomme re le parliamentary swanetše go šireletša. Re nyaka toka ye e tlotlegago, ye nago le seriti, ye e šomago ka nnete. Re thega tekanyetšo ye e fela re nyaka dilo di diragale. Re nyaka toka ya nnete ye e šomago ya setšhaba e sego ya pampiri. Re a leboga.
Thank you. Next up is the Honorable Hadebe.
Thank you, House Chairperson. A developing country requires robust institutions to safeguard its constitutional democracy. The IFP has always advocated for the rule of law, and one of the administrative mechanisms established that has been a beacon of light in post-apartheid South Africa is the Office of the Chief Justice. The Office of the Chief Justice has been allocated 2.7 billion in 2025-2026, including a direct charge for judges' salaries growing to 3 billion over the medium term. Further, it is worth noting that an additional 880 million has been allocated to the Office of the Chief Justice for various pressures, including filling in critical positions, including the appointment of researchers to support the judicial function. The IFP welcomes the additional allocation given the increased number of unemployed law graduates who can be employed as researchers to begin their legal careers and gain valuable experience. Furthermore, the IFP notes and welcomes the additional allocation over the medium term to modernize processes in superior courts through the implementation of cloud-based digital infrastructure, which will allow cases to be initiated and managed and for the evidence to be presented online. This is a real-time transition into the fourth industrial revolution. Legal fees have continuously been a frustrating reason for access to justice. We hope the outcome of the transition will result in affordable legal fees. However, the IFP shares the sentiments that budget cuts imposed by the National Treasury pose a significant risk to its modernization and digitization efforts, as these require considerable funds. While we are cognizant of the unfavorable economic position of the government, it is important to raise our disapproval of the continued neglect of our courts infrastructure. Moreover, we are dismayed that there is a shortfall of infrastructure-related support and security in courts. The constitutionally protected right to ventilate matters before an independent judicial officer required that one feel safe in that space. State witnesses and whistleblowers must not have any doubts about their safety. This shortfall has also delayed the completion of the Durban High Court to June 2026. With the court so close to completion, the delay appears to make little sense as time overruns are also costly. The IFP calls on relevant stakeholders, including the National Treasury and the Department of Public Works, to intervene and fast-track the completion of the court. Honorable House Chairperson, the IFP also commends and supports the Office of the Chief Justice plans to offer 80 judicial education and training courses each year over the medium term through the South African Judicial Education Institute to develop the skills of current and prospective judicial officers. We believe that an independent and capacitated judiciary is essential to upholding the rule of law and strengthening the democracy. In conclusion, the IFP reiterates its previous call for complete independence of the Office of the Chief Justice from the Department of Justice and Constitutional Development. House Chairperson, the IFP supports this budget vote. I thank you.
Thank you. Let me check whether there is a speaker on behalf of the PA. If not, then I recognize the Honorable Denner.
Thank you, House Chairperson. House Chair, the judiciary is of paramount importance to our constitutional democracy. We are debating the budget vote for the Office of the Chief Justice today, but at the heart of this conversation lies the question of justice, fairness, and the equitable treatment of the judiciary as one of the three independent arms of the state. Yet, it is disheartening to note that this arm continues to face systemic underfunding, inadequate infrastructure, and barriers that severely undermine its ability to serve the people of South Africa effectively. First and foremost, the issue of underfunding for the judiciary must be addressed with urgency. It is well known that the judiciary has not been afforded the same level of support and prioritization as the other two arms of state, the executive and parliament. Even the Minister of Justice has acknowledged this disparity. Such inequitable treatment erodes the principles enshrined in our Constitution, which demand that all arms of government function independently and efficiently. The recent reduction in the budget allocation further exacerbates this issue, hampering the judiciary's ability to ensure swift justice for our citizens. Without sufficient resources, the judiciary cannot operate at its full capacity, nor fulfill its mandate to uphold the rule of law and deliver justice for all. Equally troubling is the state of court infrastructure, as many other speakers have said, across the country. Many of our courts are no longer fit for purpose, with dilapidated buildings failing to serve the needs of the judiciary or the public. Under Vote 25, the Department of Justice's Capital Works Program is a critical initiative aimed at addressing infrastructure challenges. It too has faced severe budget cuts. Originally requiring 5 billion rand to tackle a range of infrastructure needs, this program has been reduced, and key projects for both superior and lower courts have been delayed or deferred until funds become available. This delay is not merely a financial hurdle, it is a direct impediment to justice. How can we expect swift and equitable justice when the very spaces meant to uphold it are crumbling? Courts that are unfit for purpose undermine the delivery of justice and, more importantly, access to justice for millions of South Africans. Turning to technological challenges, we must acknowledge the progress made with the rollout of Court Online to 16 superior courts this far, a step forward in modernizing our judiciary. In the digital era, where technology should streamline judicial processes and increase accessibility, we cannot afford ICT infrastructure failures. If we are truly committed to modernizing our judiciary, we must address all technological barriers with the urgency they deserve. Minister, we welcome ongoing efforts to secure the full independence of the judiciary. However, the pace to attain this goal is too slow. Independence is not merely a symbolic gesture. It is a cornerstone of democracy and a prerequisite for the impartial administration of justice. Yet, despite years of discussions and proposals, the judiciary remains tangibly constrained. The prolonged delay in achieving complete independence risks eroding public trust in our judicial system even further. How can we expect our citizens, Deputy Minister, to have faith in a judiciary that is not fully independent from the executive? This issue is not merely administrative, it is deeply moral and constitutional. In conclusion, the judiciary is the bedrock upon which our democracy rests. It is the guardian of the Constitution, the arbiter of justice, and the protector of human rights. Yet it stands under-resourced, overburdened, and undervalued. The budget cuts, the state of court infrastructure, the challenges in ICT modernization, and the slow progress toward full independence all point to systemic failure to prioritize justice in our nation. And justice delayed is justice denied. I thank you.
Thank you, Honorable Dana. The next speaker will be Honorable the Deputy Minister of Justice and Constitutional Development.
Chairperson, honorable members, I stand on the protocol established by the Minister. In February 2012, the Department of Justice and Constitutional Development published a discussion document titled "The Transformation of the Judicial System and the Role of the Judiciary in the Developmental South African State." Based on this document, I wrote an article that I believe is still relevant today. And I quote, "We adopted a constitution described by President Nelson Mandela as, quote, our national soul, our compact with one another as citizens underpinned by our highest aspirations and our deepest apprehensions," close quote. Despite being forged in the furnace of negotiations between those forces representing a dying and decaying apartheid past and those representing a democratic and progressive future, the Constitution emerged true to its ancestry. The Bill of Rights adopted by the ANC in 1923, the African Claims adopted by the ANC in 1943, the Freedom Charter adopted in 1955 are the tributaries that fed the wellspring that is our Constitution. Our Constitution is a revolutionary and transformative document. It is the supreme law of the land, the basis for the transformation of our society into a united, non-racial, non-sexist, democratic state founded on the values of human dignity and the achievement of equality and the advancement of human rights and freedoms. This vision can only be truly realized through the fundamental transformation of our society, a monumental and historic project requiring a democratic developmental state acting in concert with all sectors of society. Transformation is mandated, driven and guided by the Constitution. The Constitution is not designed to obstruct transformation, but to facilitate it. We're all duty-bound continuously and critically to assess the progress we're making in discharging this mandate. The Constitution expects nothing less of us. The Constitution creates a democratic state consisting of three co-equal branches which have distinct but interdependent roles to play in transforming society. The legislature exercises legislative authority by passing laws which must progressively advance transformation of the state and society. The executive is responsible for the implementation of laws and the development of policies geared towards transformation of society. The courts exercise judicial authority by interpreting the laws passed by the legislature and action taken by the executive in accordance with the Constitution. The judiciary, along with the legislature and the executive, has a constitutional mandate to transform society. However, in order to discharge this mandate, the judiciary itself must be transformed, as must the executive and the legislature. The Constitution provides that as soon as is practical after the new Constitution took effect, all courts, including their structure, composition, functioning, and jurisdiction, and all relevant legislation must be rationalized with a view to establish a judicial system suited to the requirements of the new Constitution. The Constitution entrusts this task to the Minister of Justice, acting after consultation with the Judicial Service Commission. The task of establishing this judicial system suited to the requirements of the new Constitution is a complex and multifaceted endeavor. Significant progress has been made in ensuring that the judiciary reflects broadly the racial and gender composition of South Africa as mandated by the Constitution. However, transformation is not only a demographic concept. The transformation of values and mindset, architecture of the judicial system and its administration, the development of a new jurisprudence, and access to justice are all vitally important aspects of transformation. The document proposes the following 6 measures to accelerate and deepen transformation. 1, intensifying institutional reforms that are geared to enhance the capacity of the Constitutional Court to lead the evolution of our constitutional jurisprudence. 2, making optimum use of the Judicial Education Institute to facilitate the development of an appropriate judicial education curriculum that will enhance the skills, competencies, and social context attributes of judicial officers. 3, enhancing the efficiency and the integrity of the Judicial Service Commission and the Magistrates Commission in the execution of their constitutional mandates of facilitating the transformation of racial, gender, and other constitutional attributes in the judiciary. 4, establishing a framework for the monitoring and evaluation of the implementation of court decisions by all state departments to advance respect for the rule of law. 5, building a strong research capacity for the state by re-engineering the South African Law Reform Commission and the Rules Board for Courts of Law to realize the full potential of the research capacity of the state. 6, facilitating the establishment of mechanisms for the 3 branches of the state to engage in regular debates to manage their interface within the context of the separation of powers in pursuit of a common transformative goal that is geared to benefit society at large, close quote. Recently, at the 30th anniversary of the opening of the Constitutional Court, President Cyril Ramaphosa stated that, quote, "We reaffirm our commitment to providing all the necessary support to our courts as they administer justice. At our meeting with the judiciary recently, we committed to taking steps to advance the independence of the judiciary and the future of our courts administration. A joint committee will develop an action plan to be finalized in 6 weeks from now. We will ensure the judiciary is rightly constituted as an equal branch of government with the legislature and the executive. Let us use this occasion not only to celebrate, but to recommit," close quote. That, honorable members, is what we are here today to do, to recommit to this vision. Under the leadership of President Ramaphosa and Minister Kubai, we recommit ourselves from the executive to working with the judiciary under the leadership of Chief Justice Maya to realize the vision of a fully independent judiciary in line with the Constitution. Honorable members, today we ask you too to commit to this vision by supporting the budget of the Office of the Chief Justice. Strengthening the independence of the judiciary must proceed hand in hand with the establishment of a single judiciary. For many South Africans, the face of justice is the face of the small claims court, the district court, and the regional court. It is vital that the independence, capacity, and the resources for these courts are enhanced to ensure access to justice for all in our society. We are committed to expedite the development and the introduction of the Lower Courts Bill and the Magistrates Bill in consultation with the judiciary. However, as we continue to defend and consolidate judicial independence and the rule of law in our own country, we recall that the preamble to our Constitution commits us to build a united and democratic South Africa able to take its rightful place as a sovereign state in the family of nations. Being a member of the family of nations, it must concern us that when these values, which we hold so dear, are violated by certain members of the global family of nations. Therefore, we support UN Secretary General Antonio Guterres when he says that, quote, "The rule of law is all that stands between peace and a brutal struggle for power and resources. But countries continue to flout it with impunity. I urge all nations to uphold the vision and values of the UN Charter and the UN Declaration of Human Rights and abide by international law." We also agree with him when he says that human rights are the oxygen of humanity, but one by one they are being suffocated. Human rights are on the ropes and being pummeled hard. This represents a direct threat to all the hard-won mechanisms and systems established over the last 80 years to protect and advance human rights. We must also be concerned when the judges and the prosecutors of the International Criminal Court are being threatened with sanctions. We must be concerned when the judgments and the provisional measures of the International Court of Justice in South Africa's case of genocide against Israel are flagrantly ignored
Thank you, Honourable
and
Deputy
violated.
Minister. Your time has
We
expired.
thank you.
The next speaker will be Honourable Swart from ACDP. Thank you.
Thank you, Chairperson. Chairperson, the OCJ has allocated 2.7 billion for the financial year, and as we know, this is insufficient. And the result is that key infrastructure projects for both superior and lower courts are delayed or deferred until funds become available. And as we've seen with oversight visits, many of our courts are no longer fit for purpose, and these delays undermine the delivery of justice services, frustrating access to justice. Now, it's important to note that the judiciary themselves are not able to negotiate their budget. They operate through the OCJ, and whilst the OCJ does a lot of good work, one's got to bear in mind that it is a government department. And we have expressed our concerns about the failure to resolve the matter of the judiciary's institutional independence. And we are pleased that the progress that has been made and particularly that the Deputy Minister indicated a 6-week period. It seems to be moving rapidly to finalize this operation. But as indicated before, the judiciary have had to rely heavily on the executive for its operations. And when one considers that we as Parliament appropriate the budget as well, then we are to a certain degree complicit in flying in the face of Section 1654, which requires all organs of state, that is the executive and Parliament, to assist and protect the courts, to ensure independence, impartiality, dignity, accessibility, and effectiveness of the courts. And I'm sure you'll agree with me, if there's an insufficient budget, then we are in flagrant disregard of Section 1654. And hopefully we understand the financial constraints, but hopefully this will be improved when we enhance the independence model, and that the judiciary, with an OCJ that is part of the judiciary, will be able to directly negotiate for their substantial budget. We appreciate the work of the Moseneke Committee in terms of the rationalization, and we know that rationalization will require more judges to be appointed. And this is very necessary, given the population growth and the economic growth, which has increased judges' workloads considerably. It's unbelievable, if it is correct, that the number of judges since 2008 has not been increased, and that there are a number of acting judges that have been appointed. Can you believe, if you're a litigant in the North Gauteng court, that you have to wait up to 5 years for a trial date? And so we fully believe that justice delayed is justice denied. But we are really trusting Minister and Deputy Minister and with the department that we will address these issues, that we will ensure a sufficient budget for the judiciary to enhance and maintain their independence.
Thank you, Honourable.
Thank you.
Swart. Next speaker will be from the UDM. Do we have a speaker from the UDM? Nope. Then rise, Honourable Zibi. Thank you.
Thank you, Honourable House Chairperson. Honourable Minister, Deputy Minister, honourable members. Last week marked 30 years since the establishment of the Constitutional Court. It is a moment for celebration and reflection on our constitutional journey and the administration of justice. In many areas, we have been successful, but in others, we are still left wanting, meaning that each member of the House has to do whatever they can and use their legislative authority to ensure that there is equality before the law and that there is quality justice. Rise Mzansi welcomes a long overdue progress to ensure the independence of the Office of the Chief Justice, the separation of powers envisioned in the Constitution. The separation of powers envisioned by the Constitution is vital in ensuring trust in the administration of justice. That said, it cannot be a philosophical separation of powers. It must be visible and meaningful, with the resources necessary to execute on its mandate. In short, we must ensure that the Office of the Chief Justice is adequately resourced with people, funds, and infrastructure. One, we need to ensure that the courts are presided over by the right people with the requisite skills. This includes specialist judicial skills and special courts that speak to the evolution and complexity of matters that they preside over. Two, there remain funding gaps in the OCJ budget, in ICT, in security, the implementation of the Land Court Act and court infrastructure. If the judiciary is to stand literally and figuratively on its own, it needs the necessary funding allocation from this House. Three, the courts continue to be affected by service delivery issues in the municipalities in which they operate, which severely affects the delivery and administration of justice. There are numerous instances where matters have had to be postponed because there's no water, there's no electricity. But also crucially, this does not only affect the working conditions of the judges and the lawyers involved in litigation themselves, but also the conditions under which ordinary South Africans, especially in outlying areas, then have to wait and get access to justice. The above obstacles erode the administration and access to justice, particularly for poor working class people and working class families whose time and resources do not go far. The courts cannot become another headache for an already overburdened sector of society. In closing, to quote the late Madiba during the inauguration of the Concord, he said, our constitution rests on three fundamental pillars: parliament, the government, and the judiciary. Each has its specific role to play. Take away or undermine any, you weaken the whole structure. That is why your independence is guaranteed in the constitution. We will support this report.
Thank you, Honorable Member. The next speaker will be from the NCC. Is there anybody from the MCC? Nope. The UAT, Honorable Malatsi.
Hey. Thank you, Progressive Speaker. Hodzo, Maafrika. The United African Transformation stand in this house not to applaud what is merely functional, but to call out what is failing. Budget Vote 27, Office of the Chief Justice, must be a mirror of how justice truly functions in South Africa, not in theory, but in lived experience. 2.7 billion is allocated, yet only 1.5 billion is for real programs. And despite technical increase of 880 million over the MTEF, it follows the 446 million in budget cuts. We are throwing money at the holes ourselves we created. Let's look at the facts. The court online system, a flagship of digitization, is still crawling. Western Cape and KZN High Courts are finally online, but Umtata is only being prioritized after corruption allegations. The Land Court and Labor Court are still progressively joining. A tender irregularity with Thomson Reuters saw corruption of OCJ officials self-dealing as subcontractors. The court had to declare the case line's contract invalid. So much for an ethical justice. At Mthatha and Pretoria High Courts, we have cases of corruptions, Hawks investigations, lifestyle audits underway, and officials suspended. Meanwhile, ceilings collapse, sewage leaks, bad waste disposal violation in courtrooms. On the other hand, the Durban High Court completion has been delayed again to 2026, while people suffer in a decaying magistrate building. And still we hear promises of accessible justice. Progressive Speaker, one cannot digitize this function. On judicial transformation, the Museneke reports on High Court rationalization recommend new local seats. In Rustenburg, Thembalethu, Welkom, but there's been no increase of judges since 2008. The committee called for data and policy. The UAT called for agency. The Constitution demanded the rationalization process as soon as practical. It has been 30 years. The Land Court Act.
Thank you, Honorable Member. Your time has expired.
The Speaker, you are a progressive Speaker. Give me 2 minutes. The Land Court Act of 2023 remains
your time is expired, unfortunately. Thank you.
Speaker, do the right thing.
It's time for
you are a progressive. Do the right thing.
Thank you, Speaker.
Fine. Do the right thing, Speaker. The Land Court Act.
Honorable Member, your time has expired. Thank you, Honorable Member.
There's no dignity in owning the
Honorable Member, your
justice about
time has expired. Thank you.
Nimambo.
The next speaker will be from the DA, Honorable Klopper.
Thank you, Honourable Chairperson. I rise on behalf of the Democratic Alliance to debate the budget allocation to the Office of the Chief Justice, a crucial cog in the greater state machinery to promote and protect constitutionalism, accountability, and the rule of law. The Office of the Chief Justice is foundation on which the judicial independence and the administration of justice is ensured. Yet to many South Africans, the justice system is a source of frustration. The budget must signal a renewed commitment to the functional justice system that promotes the rule of law, fairness, and accessible justice to all. The Democratic Alliance remains committed to restoring what corruption, cadre deployment, and executive overreach have damaged over the past 30 years. Nowhere is that restoration more urgent than in our justice system. The Office of the Chief Justice is central to keeping the wheels of justice turning efficiently, fairly, and independently. We have to ensure that these wheels are turning in the right direction. South Africans are tired of waiting for trial dates and long overdue finalizations. Our courts are plagued by perpetual delays, often due to the absence of court interpreters or even power outages. In April this year, proceedings at the George Magistrate Court were halted due to a strike by unpaid court interpreters. Courts in Johannesburg are buckling under the pressure of chronic interpreter shortages. Many courts face rolling blackouts and often are forced to halt proceedings mid-session. These daily disruptions deny people their right to timely justice. We found on oversight visits that access to justice is hampered by a lack of resources, understaffing, and ongoing technological and infrastructure problems. These problems are getting worse as time passes. In 2024-25 financial year, the OCJ received 83% of its annual targets, compared to 86% of the previous year. This decline was largely due to budget reductions, which directly affected the department's ability to recruit and retain critical staff. Overspending of 108 million during the same period either reflects systemic underfunding or points to inadequate financial planning and internal controls. Either scenario demands scrutiny. Results in digitization efforts by the OCJ remain limited and visibly glaring. Only 15 courts have implemented the court online system to date. Oversight visits have revealed unreliable internet access at many courts. How can a prosecutor actually do their work if they do not have access to their emails? And oversight visits, the neglected state of safety infrastructure such as metal detectors, surveillance systems, and fire extinguishers was obvious. Ill-maintained security systems resulted in a fatal shooting in the Wynberg Magistrate Court just in April of 2025 this year. Honourable Chairperson, the Democratic Alliance believes that good governance is achieved by spending wisely, not spending more. We must improve how we use what we already have. Unnecessary expenditure must be eradicated, and existing systems need to be properly maintained to function properly before investing in new ones. Despite the 880 million boost over the medium term, the OCJ's real budget grows by under 1% in 25-26, with ongoing shortfalls in funding for land courts, infrastructure, ICT, and very crucially, court security. Where the OCJ has received additional allocations under the MTEF, this must be matched with improved service delivery and definitely not bloated administration. That means filling critical vacancies where backlogs are the most severe. We must protect the integrity of the judiciary by being proactive in security, system maintenance, and workforce planning. This is how we promote functional judiciary that serves the public. Honourable Chairperson, the Democratic Alliance is steadfast in its belief that budgets must reflect the needs of citizens, not the preference of bureaucrats. We will continue to defend the independence of the judiciary by ensuring that the OCJ receives the resources it requires. Every citizen, regardless of income or status, should have access to justice systems that actually deliver. I thank you.
Thank you, Honourable Member. The next speaker will be from the ANC, Honourable Motahong.
Thanks, House Chairperson, Minister and Deputy Minister of Justice, Members of Parliament, Director General, Acting Secretary General, and members in the Office of the Chief Justice. House Chair, the belief of the separation of powers is rooted in the philosophy that aims to keep power from consolidating. in any single person and or entity. The aim of separating powers is to avoid accumulation of the different functions of government. Philosophers understood that the consolidation of the legislative, executive, and judicial powers in the same hands will be equal to establishing dictatorship, resulting to abuse of power. The belief of the separation of powers requires interdependence amongst the three arms of government to ensure checks and balances between the different arms of government to enhance accountability, responsiveness, and openness. While this belief is not expressly provided for in the Constitution, it is a clear part of our constitutional order. It assists in fostering accountability of government to its citizens. It fosters respect for the rule of law, balances public power, gives the government legitimacy, and contributes to economic development and social stability. Against this backdrop, it is important to remind ourselves of what former Chief Justice Arthur Shackleton had to say. I quote, "Judicial independence is a requirement demanded by Constitution, not in the personal interest of the judiciary, but in the public interest. For without that protection, judges may not be or be seen by the public to be able to perform their duties without fear or favor," close quote. Chairperson, the Office of the Chief Justice, as a separate department, was established as a measure to promote and reaffirm the principles of judicial independence. As graduated by the Section 165 of the Constitution, this budget vote contributes to as a just, peaceful society by rendering support to the Chief Justice in executing their administrative and judicial powers and duties as a head of judiciary and head of the Constitutional Court. These votes provide support to the judicial education through the South African Judicial Education Institute, which is responsible for the education and training of judicial office. South African Judicial Education Institute offers courses of judgment writing, case management, and constitutional rights. An amount of 2.7 billion is allocated to OCJ for 2025-2026 financial year. 1.5 billion is allocated for the vote, and 1.2 billion is a direct charge for judges' salaries. Over the medium term, an additional 880.8 is allocated to the OCJ. We are concerned about the shortfalls. As the ANC, we have been consistently raised the issue of safety of judges and court officials. We have consistently raised the issues of infrastructure and ICT challenges, which must be resolved as they speak directly to the question of access to justice. The committee on the rationalization of areas under jurisdiction of judicial establishments of the divisions of high courts, which was chaired by former Deputy Chief Justice Moseneke, concluded that the judiciary was in a state of crisis, which was a result of many years of the non-appointment of permanent judges to meet the rising caseloads. The committee concluded that the shortage of judges had led to significant delays in the handling of cases, thereby creating backlogs, and that it has severely hampered on the access of justice. The Department of Justice and OCJ needs to consider and implement the recommendations which were made by the Moseneke Committee. Chairperson, as our democracy matures and as we increasingly rely on technology, the OCJ should continue to focus on digitization. We appreciate that court online system has been introduced in superior courts to ensure electronic filing, to enhance access to the people of South Africa while increasing efficiency and reducing paperwork. The court online system allows legal practitioners to file documents electronically without having to be physically present at court. The system also enables managing court appearance, diaries, and court evidence immediately online without hassles. We believe that this will contribute to significantly reducing case backlog. The Office of the Chief Justice had set a target on rolling out court online to 15 superior courts over the next 5 years. It will be implemented with an additional of 98.2 million over the medium term allocated in the administration program. It has been reported that the civil online system functions in more than half of the high courts, with full rollout expected by the end of 2025-2026. A system of managing criminal cases is being developed and will be introduced over the next 2 financial years. Chairperson, institutions like the judiciary, which holds and use public power, are struggling at their services. The importance of a strong and independent judiciary cannot be overstated. It is part of the transformation enterprise and the democratic project to make our country reflect the text and living spirit of our Constitution. The need to safeguard judiciary integrity and the beliefs of the separation of powers in South Africa must be top priority of all concerned citizens and all 3 branches of government. Speaking at the 30th anniversary of the Constitutional Court, President Ramaphosa reaffirmed government's commitment to judicial independence despite South African tightening physical environment. As the ANC, we too reaffirm our commitment to the independence of judiciary. Judicial independence is not a privilege. It is a pillar of our constitutional democracy. The ANC, the African National Congress, supports the budget vote 27 of the Office of the Chief Justice. Thank you, House Chair.
Thank you, Honourable Member. The final speaker for the day will be the Honourable Minister of Justice and Constitutional Development. Thank you.
Thank you very much, House Chairperson. Let me acknowledge and appreciate the support from all the speakers and the parties for this as a critical budget for our work and also in support of our country and the judiciary at large. Honorable Kola and other members raised the issue of infrastructure. I can confirm, honorable members, the issue of infrastructure of our courts remains a critical issue that we must address. We made a request as the Department to Treasury of about 1.4 billion in terms of resources that we required for the infrastructure of the courts for this financial year. We're given 400 million. So out of that, the conversation was held with Minister of Finance, a commitment. That's why you would see that statement in the budget vote, because at the time we engaged, the budget was almost completed. So there is commitment to addressing the issues of infrastructure across. Similarly with the water and electricity, Honorable Zibi, what we have done, part of just ensuring that there's work that is being done. In some of the courts, we've put water tankers so that water can go in, and also alternative energy, so that there's no disruption. So, but we still emphasize the importance of municipalities to be able to provide these services, because it takes out of the budget that we desperately need for other issues. But work is being done. For example, Constitutional Court, the courts, major superior courts will have backup tankers in terms of water so that they can continue. Honorable Muhlala, I agree with quite a number of observations that you've made on the ground. Ga re bolela ka hore swantse hore batho ba kgone ho hwetša tokelo tša bona, re bolela ka molao mo e le hore motho a kwele botlhoko swantse hore a ile hore o ile a violatiwa or gwa diragala se sengwe a nyaka go ya dikantorong tša rona swantse hore a hwetše thušo jalo ka se le se bolelang ra kwana mara ka se sa online court online re ile court ra hwetša judgment against that. We published it. We'll provide the report to the committee so that the committee kgone gore e bane le report we mara re kwana le lena ka tše le re kampana ra ska kwana gore swantse gore di lokišiwe jwang mara se le se bolelang sa di deadline di delays tše dingwe re di hwetša re ya intervene re bolele le bona mara gape mathata ke tlo ilinka gape le what other members have raised in terms of capacity. I think various members have raised Swart, Honorable Member Swart, Malatsi and others in terms of capacity of the judiciary. For example, we said at JSC during the appointments, we were looking for appointments for judges in the labor court. Out of 3 vacancies that were there, only 1 qualified. So it's not just an issue of money. There are quite a number of things that we must address. People who are ready, candidates that are ready and suitable to be appointed as judges so that when they go to the interviews, they can pass. I mean, we were looking for 3, we could come out of 1. So it's some of the challenges that we have, but we are paying attention to that so that we can respond to it. Similarly, the issue of rationalization in terms of the report, not all elements are being agreed to. So there's still contestation about the content. We are going to meet with the former Deputy Chief Justice, but also the judiciary as well as we meet in our quarterly meeting. It's one of the issues that we are going to try and address so that we can holistically look at what we are addressing in terms of the judiciary. Honorable members, it's a commitment of this government to say we must move. That's why there are time frames. We must move to the full independence of the judiciary. So I can assure you, as we talk here, we'll come to the portfolio committee in 2 months' time. Once cabinet has looked at that, we'll update the portfolio committee so that you can monitor. It's long overdue. The president has put deadlines for us as the department to be able to implement that process so that the judiciary is not bent and waiting for the minister. And I'm also uncomfortable as the Minister of Justice to have to account to certain things that I have no powers of. What happens in the courtroom, and I get asked those things, but because certain responsibilities are with the minister, you get asked those things. So it's a bit of a challenge that we must address. As I conclude, I think I want to address the issue of Honorable Nomval. The first one, I agree with the issue of the lower courts. We are agreeing, that's why my statement talks about single judiciary. So meaning that the lower courts will be under the Chief Justice, under the leadership of the judiciary. So we agree on that in terms of the issue. But I think let's come to these issues. For example, the reflection in terms of the characters. One can agree that not all, they are human beings. That's why one could say Sitembegini, you know, and then we ended up having to impeach a judge. So it's a reflection that indeed we do find corruptible ones. But again, the issue here, Honorable Member, it's the issue of ensuring that as we do the work, we do that within the bounds of respect. And I appreciated this and I raised it in the committee, that when we do our work as members of parliament, let's do it within the boundaries of respect and the boundaries of ensuring that we can uphold what the South Africans are expecting of us, of holding each other accountable. I'm one that is not afraid to be held accountable. I will come to the committee and account. But the disrespect shouldn't be. Because when we go, we'll start reflecting on each other because of the parties that do not have direction, even can reflect on tribal issues without understanding the constitution. And bakhulume ngendaba ze-tribal abangazi-understand umuntu azathi kunamashangana aselimpompo. When we do not have in terms of the constitution. Because the constitution, as we protect and uphold it, it means we must uphold it across as the parties. We must be able to say, as leaders in terms of political parties, we must be able to say we do have. But
Thank you, Honourable Minister. Your time has expired. Honourable Minister, your time has expired.
The leaderless.
Thank you, Honourable Minister. Your time has expired.
I want
to. Can I recognize the? Do you have a point of order, Honourable Member?
Yes, Chair.
It's fine.
Chair. Chair.
His hand was up while she was on the podium.
Yeah,
Okay, it's fine. Is it a,
Chair.
honorable member?
Yeah, bengizama ukuthi ngilungise ungqongqotshe la athi khona
Honorable member, that's not a,
Chair.
that's not a point of order. It's fine.
No, there's a point of order.
Thank
I'm
you.
saying, Chair.
Thank you very much.
I'm saying, Chair,
And the business of this mini plenary session, the mini plenary will now. Thank you.